defense presented at trial.
Tell us how the defense actually argued in the penalty phase the mitigating.
Well, they attacked the aggravators, and then
I'm sorry, they did what?
They attacked the aggravating circumstances
Okay.
and spent time on that, and then they discussed the mitigation from the sister and the mental health.
I guess the real question, though, is did they discuss, if they were relying on the information that was presented in the guilt phase about mental health, did they re-argue in the penalty phase the evidence that was actually presented?
My recollection is they did. They were seeking the statutory mental mitigators. In fact, they got one of those from the trial judge, actually found one of the mental mitigators and found the second one without the adjective of substantial. Found that his ability was impaired but not substantially impaired.
So you're telling us that they did, in fact, argue in the penalty phase what was actually presented?
Your Honor, I don't have a specific recollection. I didn't review that part of it right before I came here, and I don't remember exactly what they said on that. I remember reviewing my notes that they had, addressed the aggravators and addressed the sister's testimony, but I don't remember exactly what they said. I couldn't tell you. I'd have to go back and look at that.
And to what extent did the sister's testimony actually talk about their life growing up?
She talked about that they were raised in the low-income housing projects that he quit school at 9 years old, after ninth grade, that he quit school to go to work because they were low income and that the father was abusive and they had to support the family by going to work. And I would add that by going to work, Diaz went to work as a busboy at restaurants and various things like that, and eventually ended up at a lumber company. This was not migrant farm work that he was doing. Again, the testimony was that he did I think a week one time at 12 years old in farm work, and then pretty much the remainder of his work history was all.
Well, as I understood, part of their argument is that he spent a lot of time in the fields, and that he was subject to a lot of pesticides and herbicides and those kinds of things. And so what do we have in the record that supports that he had this kind of exposure?
There was testimony that they brought in from a social worker and from a professor regarding the whole culture of migrant farm workers, and they talked about various vague interviewing things. But what came out of that was that Joel Diaz reported one time being sprayed with a pesticide. The evidence showed that he apparently had accompanied his mother at various points in time as a 10 to 12-year-old child in the field. But the Social Security records, the income records, showed that he had only received, I think it was $300 in pay as a 12-year-old for working in Quincy, Florida at a packing house or something of that nature. There just simply wasn't that much. They try to paint the picture that Diaz is living out on a migrant farm, and that's not the case. He was living in the city of Fort Myers in a residential area from age kindergarten, 5 years old, all the way through. His work history, mainly as a young adolescent up till the time of the crime, was all restaurant-type work or working for the lumber yard, where he had worked for, I think, 4 years prior to the crime.
Remind me of what's the time frame between the time the victim that was shot?
Right.
What was the time frame when they stopped living together? She moved it back in with to the time.
It was, I believe, 8 or 9 months that they had been broken up. They hadn't even spoken for at least a month, I think, before. But I think it was 8 to 9 months breakup before the murder actually took place.
So, and what was going on during that time period?
Not much. He was texting her, basically trying to reestablish contact with her, and she didn't want to engage in that and wouldn't return his text and that kind of nature of it. But like I said, it had been a month before they had any contact prior to the actual murder. And they had lived together for, I believe, I think they dated for 2 years and lived together for a year. And she had testified pretty extensively as to the whole adaptive functioning and the mental retardation claims. So
but I guess I thought I remembered something about various contacts between them from that time where he tried to assault her in a parking lot or something.
Right. There were incidences.
So there was some kind of contact between them of a violent nature, I assume, between the time that they broke up and the time of the murder.
Right. There was this Western Auto incident where the victim, I believe, he approached her and tried to kidnap her and beat her or what have you, and that she filed a restraining order against him. But that was months before, if my recollection is correct. That was
okay. And my final question is: what is the state of the record about any kind of mental health counseling or anything about this?
I don't believe he ever had any. I don't believe that there were no experiences with any kind of mental health practitioners prior to them being appointed in this case. I don't believe he had ever. I think the experts asked him that, and he said he had never seen those or never seen a psychiatrist or any kind of mental health expert. I wanted to basically briefly go over the file thing with Dr. Crowell's report. She indicates that it wasn't in his file, but I will point out that it was actually mailed to Frank Porter. So I'm just troubled by this court finding that things that weren't in their file and that they couldn't recall show deficient performance. And I want to stress that basically it was over 10 years, or about 10 years, I think it was, from the time of the trial till the time of the evidentiary hearing, and counsel had a difficult time recalling what all he had done.
I mean, but it's clear that these records were not in their files.
Yeah, right.
Now, whether one attorney says he actually had them and saw them,
right,
I mean, that could or couldn't, may or may not be the case, but we do know they were not in the file.
Right.
I just is there any indication that anything that was in these records was actually used during either the guilt phase or the penalty phase of the trial?
Well, as I said, the two experts' reports were actually introduced into evidence. The third one was not. Dr. Crowell's report was never introduced, and it's a much briefer report. I think it's only 2.5 pages long. But the other two were admitted into evidence, one by the state and one by the defense.
And they show that they reviewed the school records?
No, they do not.
Well, I thought that was...
The testimony was that he basically had done average in school, which was accurate when he put forth an effort, apparently. But
would they, again, this shouldn't be that hard. Would they, if a child drops out in 9th grade and he's failed 2 years, that's not doing average in school.
Well, he testified that he failed the kindergarten and 2nd grade because language. He grew up in a Spanish-speaking home and then moved into an English language classes. But his grades reflected...
He testified when about that?
Well, he didn't. I didn't mean to testify. He told that to Dr. Gamache in his interview, and that was videotaped.
What do the records show about why he failed those grades?
Well, I think that's probably accurate based on the school record. I don't think his...
You failed kindergarten because...
He couldn't speak English. The school records show that he was more than capable of making average grades. Whether, as Dr. Gamache said, they don't show any indication of intellectual impairment.
So he only dropped out of school so
to
he
go to
could
work.
Help his mother.
Right. He wanted to go to work to support the family.
At what age was that?
It was when he was in 9th grade, and he was older than your average student. I don't remember. I think 14 or 15. I'm not sure.
Well, if he failed 2 grades, it seems to me he would be, 15 or 16?
That may be.
17
it may be
at that point.
I think it was 15, but I'm not 100% on that. For some reason, that sticks out because I believe he started working as a bus boy at 15 or 16 at a Perkins, and I think that's when he had quit school. I wanted to very briefly, talk about the juror issue. The juror never gave any false answers in this case. She was never asked...
What was the actual state of the juror? Had been arrested?
She had been arrested for domestic violence and completed a pretrial intervention program prior to jury selection. She was never asked had she ever been arrested. The jurors were asked if family members or close friends had ever been arrested, and all of them responded appropriately as to that. Only one juror relayed his own personal experience with the law in front of the entire veneer. So I don't even think it's reasonable that you can say that, the jurors were on notice.
And this person actually served on the jury?
Yes, she was the foreperson. Yeah. I would ask this court to affirm the trial court's order denying post-conviction relief. Thank you.
Justice Quince, Mr. Diaz and Lisa Shaw lived together until August of 1997. when they broke up, and this crime occurred in the end of October. There was evidence that was presented in that was in the report that there was a restraining order that was obtained, even though everyone agreed that
there was evidence that
she tried to get a restraining order against him. That was entered into evidence in the report.
And when was that restraining order?
It was never served on him, but it was a result of a violent incident. And
if they went ahead and they have all this mental health information in the guilt phase, why is that not reasonable then to refer to it and argue it in the penalty phase?
Because they didn't argue it. And Justice Quince was asking about what Neil Potter argued. I set forth what he talked about on that issue on pages 22 and 23 of my reply brief. I just put the whole transcript. He mentioned Dr. Kling one time. At the beginning, he said, I want you to find the statutory mental health mitigators, but he never said, take a look at those reports that are in evidence. He never suggested it. So this idea that they were entered into evidence strategically is just not true. It was like secret mitigation. They weren't even published to the jury.
Were they a part of the penalty phase also?
Absolutely not. They were never mentioned one time.
Did the experts testify during the guilt phase?
During the guilt phase, Dr. Keown testified and Dr. Kling testified. But Dr. Kling
were those the reports that you're referring to?
Those reports were then entered into evidence during the guilt phase.
After the people had testified?
Correct.
Did they testify fully, or did they just say their names?
They did not testify fully. Dr. Kling talked about the weeks leading up to the crime with respect to the insanity, but there was no discussion in the guilt phase by Dr. Kling about the family violence, the sexual abuse that he found. No one ever asked him about the sexual abuse, and that wasn't strategic.
No, that would have been because that really doesn't have anything to do with the insanity.
Right, which is why you need to focus on it, even if you're just relying on these reports. And Dr. Kling was kind of destroyed in the guilt phase. That's when you go to Dr. Crow. In Dr. Crow's report.
Destroyed in what way?
That the prosecutor was able to show how many of the facts he didn't know, and they rejected the insanity defense. And the trial prosecutor was able to establish that he really didn't know many of the facts that he should have known. And so I think the jury would reject his testimony.
Are we talking about many of the facts about the crime?
The crime.
Which would have demonstrated whether he was insane at the time of committing the offense versus many facts about his life and that kind of thing.
Right. And then Dr. Crow never testified, and his report was never entered into evidence. It was in one attorney's file, but it never made it to the other attorney's file, and they said they didn't know about the low IQ.
I'm looking here at what you actually quote in your brief, and he does make reference to Dr. Kling's testimony.
About the mental infirmity. That's it. He doesn't say take a look at that report where he talks about the sexual abuse. He never asked.
Well, he says, that he was suffering from mental infirmity. Once you got, I should consider what Dr. Kling had to say. I mean, so he's referring them back to that.
In the guilt phase. He didn't say look at the reports. He never said look at Dr. Keown's report, take a look at Dr. Kling's report. And they weren't published to the jury. So the jury would have had to affirmatively say, we want to take a look at this report.
They'd have to go and find the exhibits from the guilt phase.
Correct.
Look at a report.
On their own.
After how many months between?
Exactly. Right. And so this is kind of like an after-the-fact strategy. It certainly wasn't strategy to say, well, we're going to rely on reports.
What did the trial judge, as I understand it, the trial judge actually found both statutory mental mitigators, and what were those based on?
I don't really know. I know that Dr. Kling only found one of them, and the trial judge actually found both. And I think under Porter, it's clear that even if the trial judge found these mitigators, the issue is that the jury, we don't have any idea what the jury heard.
But you have no idea what the trial judge based it on?
No, it's not actually clear. It's almost like they were based on the same evidence is what he found it on, based on the same testimony by Dr. Kling in the guilt phase. But the trial judge is sophisticated. He knows he can look at the guilt phase testimony. The jury was never really
told that. Was there a Spencer hearing?
There was a Spencer hearing.
Did they argue the reports in the Spencer hearing?
No, they did not. The issue primarily in the Spencer hearing was the CCP. And the attorney, Mr. Diaz, did say he did not want his mother to testify at the Spencer hearing, but that has nothing to do with failure to investigate. Minerva and her mother went and talked to Dr. Kling, but that information wasn't followed up on. Joel Diaz, it's just not a fact that Joel Diaz did not want to cooperate. It's not true. After the penalty phase, he was upset about some of the information that came out. It has nothing to do with why there wasn't an investigation in this case.
Thank you for your arguments. The court will now take a 10-minute recess.
Thank you.
All rise.
Supreme Court of Florida is now in session.
The last case on our docket for today is the Florida Bar versus Buckle. You may proceed.
Thank you, Your Honor. If it please the Court. My amended initial brief sets forth the issues I believe, and I'm understanding from correspondence that you have read those and that brief and are familiar with it. I'd like to argue that several things that weren't clear therein. More than 180 days passed between the filing of the complaint and the final report by the referee, and I filed a motion to dismiss it, and I don't believe there was any justifiable grounds not to dismiss it, so I'd like to use that point. I'm sure a question everyone has is, why would somebody do what I've alleged? My mentor and sage is a former law professor at Stetson Law School, Mickey Smiley. Back many years ago, he announced at a faculty meeting that as long as he was the senior faculty member, that no lesbians or homosexuals would be hired by the law school. They began a crusade against him. They spent over $100,000 in an investigation to try to trump up something on him. A former law student, Kendra Presswood, on behalf of a lady who tried to become his research assistant, filed a lawsuit against Professor Smiley in the circuit court in Pinellas County, alleging 7 counts, including trying that Professor Smiley in the interview process had attempted to get her to violate the pimp statute. A civil lawsuit was brought. It was great humiliation to Professor Smiley. The suit was ultimately dismissed with prejudice. Kendra Presswood sent a unsworn complaint to Stetson Law School demanding $90,000, wherein, when it was dismissed, all 7 counts with prejudice, I believe some prejudice began to emerge in regard to Professor Smiley, my best friend, and has been for a long time. His mother was friends of our family. My mother grew up with him. Now, Kendra Presswood later became my investigator in the case before this. And when we accidentally discovered that Kendra Presswood was the managing attorney for the National Center for Lesbian Rights, all of a sudden the case that preceded this one against me for these same issues, basically, it all got dropped. That has always been curious to me. It's our position, my position, that they sought payback. It is common knowledge on the streets that the referee that tried my case is a lesbian down in Naples, Florida. Well, what has that got to do with anything? I am well known in my community for being strongly against those things and taking stands against them. I've been persecuted. I've had signs in my window that said abortion kills children. They've done things to my building which I no longer have an interest in that defaced it, threatened to kill me and people that worked inside. I have strongly defended my position, my religious beliefs, and they have been under scrutiny and attacked by every liberal in the community in which I live. I do believe that abortion is wrong. I can tell you that as a result of the signs in my windows of my law office, which is a block from the courthouse, at least one child avoided abortion and was given up for adoption. They raised the fact that I did something by asking Judge Gonzalez, who recused herself without any notice to anybody, that she recused herself because of the questions I asked her. If I represented a black man and I knew or suspected that somebody that belonged to the Ku Klux Klan may be on the jury panel, I believe I would be committing malpractice if I didn't actively investigate that person in voir dire and discover whether or not there was any basis or possible prejudice. I believe there was prejudice here. I believe that I was selected, and I stand firm on the fact that I didn't do anything that is alleged. I was diligent. I represented Mr. Wolf to the best of my ability. The allegations against me are false, and my failure to admit them is not that I'm stiff-necked, rebellious, and avoiding facts. I'm simply telling this court I've been practicing in the family law courts for many years.
Could you just, on the allegations regarding Mr. Wolf, the referee's findings are that you were retained for the purposes of filing an emergency petition to regain custody, and you understood the urgency. And what is not correct about, after being paid the fee, that you did not take immediate action in that case?
As I stated in my brief, I wanted the expert witness for the bar, Larry Chulak, testified that it is also his practice not to begin work until the contract is signed. Mr. Wolf was out of town. His mother and sister brought by a retainer, and work commenced when we got the contract signed. I do a lot of these cases, and I did file an emergency petition. When I discovered in our initial interview that Mr. Wolf had been guilty of all kinds of things and was in jail writing letters to the two county judges to the effect that he was mentally ill and suffering from bipolar disease, and he wanted out of there. He was in jail because he'd been ordered as part of a domestic violence petition to enroll in and complete the Certified Batters Intervention Program. He kept skipping classes, so there was a violation of probation put out, and he was in the county jail. And I did not believe, based on my experience, that going before a circuit judge without any immediate danger on the issue of temporary custody. Custody had never been decided in this case. This child was born out of wedlock. He was 8 years old. I'm well aware of what abuse is. I co-founded Manatee Children's Services. That's been a $1 million agency in my community. I think anybody in the town that knows me would know that I would never do anything to jeopardize the safety of a child. So to answer your question, this wasn't a modification of custody. Custody had never been decided. And Mr. Wolf basically told me that all his motive was to get out of paying child support. His plan was to let his son live with his mother in Bradenton, and he couldn't live there on a temporary basis because she didn't have room for him. And so that was his plan, to get out of paying child support to free his lifestyle up. And he also wanted me to handle a case, which I never got into, to get out of child support in Sarasota, Florida, to a mother of another child he had, born out of wedlock, who he used to beat up and make false accusations against, and who he reported as being a danger to that particular male child. And the investigation revealed no such thing. I don't know if that answers your question thoroughly, but my position is that this case has been bolstered and by the motive of folks to get rid of people like me that stand firm in the community in which I live.
But that is a very serious allegation that you're making, even about the motive of the bar's expert. What you're saying, are you saying that the bar is motivated in this case by animus towards you because of your political or social stands?
Absolutely.
But what...
Larry Chulak, the bar's expert, he's only been practicing law around for 8 years. He's not board certified. I had a custody case with him, and he stated on the record, I'm a Jew, and it offends me deeply that you put certain things in your correspondence. For example, at the end of every letter, I quote the prayer that Moses prayed over the Jews. Numbers 6:24. May the Lord richly bless you and keep you. May he make his face to shine upon you. That's a blessing on people. That's different than sincerely yours, but I do that. At the end of every pleading that I've put for years, it says, in this the year of our Lord and Savior Jesus Christ. And I took Jesus Christ out of it because my bar license says, in this the year of our capital L-O-R-D. So does my license to practice law in the Supreme Court of the United States. And L-O-R-D capitalized is reference to Jesus Christ. This is a payback to Professor Smiley and me as his friend for taking positions we have. I'm here to tell this court that within the Bar Association are a group of radical feminists and their allies who absolutely hate everything I stand for. I'm a white male, I'm over 60, and I'm not politically correct. And yes, I'm saying that. I know it's a serious allegation. I've been doing this a long time, and I wouldn't make those allegations if I didn't firmly believe in it. To say that there are folks out there that are gathering to do something to discredit me, I understand at least 3 of you have had some folks out there trying to discredit you and prevent you from being retained in the position that you are by virtue of different political philosophies. Well, my philosophy and my beliefs are what they are, and they have been for a long time. So yes, I do believe that. And I don't take lightly what I've accused.
Well, how would you, you're just trying to understand this. You have a First Amendment right outside of the practice of law, certainly to express your beliefs. You're not being charged, as I understand it, with putting something that is politically incorrect someplace. But what you're asking this court to find is that the referee's findings of fact and the expert that testified have no validity because you are alleging, in a way outside the record, that there's a pattern of animus against you. And you must understand, since you've been practicing law since 1973, that this idea that there's a conspiracy theory sometimes makes someone think that that's, maybe there is an element of people are out to get me, but if you're sitting here as the court and we're sympathetic to the idea that you have that right, how do we establish in this record that that's what was done? I mean, you mentioned Professor Smiley. I remember Professor Smiley. I don't know what it's a very interesting story, but what does that have to do with the 4 corners of what we're reviewing?
If you review it, and that's I understand your position. If you review the record, it's abundantly clear that to draw the conclusions that the referee did based on the facts before her is like me deducting that the Chicago Cubs are going to win the World Series next year because they win 5 out of their first 12 games. There's no justifiable basis for relying on the facts.
Could I ask this maybe approach it in this fashion? The substance of the claim is that there was an allegation that there was a child at risk of danger. Is that a fair statement so far?
That was the allegation.
And then the allegation is that this person, a person, came to your office and asked you to file emergency relief to remove that child from the custody or from the control of the mother. Is that fair so far?
Yes, sir.
And that I'm not sure how you would refer to it time-wise, but the family or someone came and delivered, I believe, $1,500?
Correct.
And that then the next is then I guess where the dispute arises is that there's nothing that happens in the filing. Nothing is filed. Is that a fair statement?
True.
And that was there during that time some allegations that the child, in fact, was involved in some kind of incident or that the mother and her boyfriend were arrested during that period of time that we're speaking of?
That is true. And they were in jail in Sarasota for possession of heroin.
Right. So that was the concern. And then is it also, as I am reading this, trying to understand it, is that for whatever reason, and it could be animus, could be whatever, but that some 3 weeks later, about 22 days later, somebody from the Florida bar called to ask about the case?
Ted Littlewood.
Is that correct? Am I correct so far?
It certainly is.
And then
I called him the same day.
Okay, all right. But then it was after that phone call, and I'm not sure I have the exact number of days, but it was some days after that you then filed for some kind of emergency relief?
I did.
Okay. And the allegation was, and maybe you have a legitimate legal defense, but the allegation and the thrust of what they were saying is that counselor that you did not take emergency action, and what they founded on is some of these rules, and sometimes they seem a little formalistic, but that after the first day you did not take action for some 42 days, and they're alleging that breaches the code with regard to representing client. And secondly is that there's some situation about you being ill and no one returned any calls that were made.
That's absolutely false.
Well, I'm just saying that's allegation.
Yes.
And that's what is a finding of violation that we're looking at that's come to us.
I understand. There's no evidence to support that.
Well, did you say that you indicated at the final hearing that you had been out sick for a few weeks?
On and off, I had been out.
Well, is that, I mean, what was the reason, it goes back to this, that after the retainer is paid, the client indicates he called you repeatedly multiple times a day and received absolutely no word back, and so that begins the problem of what leads to this complaint. No huge, I mean, this is something the bar, next to trust account cases, client neglect is a big deal to the bar. So, and it wasn't just that. So we're dealing, maybe disbarment isn't warranted, but what you're really defending on is that you shouldn't receive any sanction. Is that what you're saying? You didn't do anything wrong here?
I did not. And there's a great gulf there where I did a lot of...
What would you say? Let's assume that we find that you did something wrong with this case.
Okay.
All right? No animus, no just looking at the facts, looking at the record, that we think it looks like you did, whether you intended to or didn't intend to, that you neglected this client in this case. What is, in your view, looking at the law about remedies, about sanctions, you have some history of having previous actions with the bar. What would you say is the appropriate sanction the court should impose? Since if we find a violation, we've got to impose some sanction.
No disrespect, but I don't think you should find a violation.
I understand that.
If you did,
right.
I don't think there should be any penalty. Don't think I've done anything wrong.
That doesn't help me.
I understand.
We need to know, this judge has said you should not be able to practice law.
She did.
Okay. So we have to decide if that's assuming everything's true about what she said for this instance, we ought to know if that's the proper sanction or whether you ought to have a suspension for a period of time. Can you help us, looking at all the case law from this court, and if you were advising, say you were representing someone like yourself, what would you say would be, do you have an idea of what would be a reasonable sanction? I know that's a difficult argument, but I'm trying to so we can get to a middle ground here to understand whether you appreciate that assuming the magnitude of what you did, it's hard when you say, well, you did nothing wrong, but let's assume you did something that the bar and this court thinks is not proper. What is the right sanction?
I can't tell you that. Lots happened between the time frames that Judge Lewis is talking about. I spoke with the mother of this child on several occasions. I spoke to the mother's father. The mother was a woman I knew for years. My wife and I used to eat dinner in the restaurant that she worked at.
Well, but okay, so you had a personal relationship with the adverse party here.
I knew her. I talked to her and noticed her about a hearing that was scheduled.
You're telling me about your personal relationship with her. And did that affect the way you went about doing your job for your client? Because you had a client.
Yes. No, it didn't. I'll tell you what that relationship was. I saw her in the restaurant. She served us. She was very proud of her 8-year-old son. And, I was aware of the fact through her father that this child was being well cared for by this lady's sister. This child was in no danger.
But you see, it sounds to me like what you're now going back to arguing the facts. You're saying you made your own determination that this was not an emergency matter, but you were hired because the client felt it was an emergency, and you eventually filed it as but belatedly. So,
yes, ma'am, and I told him that in my experience, filing these emergency motions, there weren't enough facts to
that's
justify.
What you told him at the time you accepted the retainer of $1,500?
Yes, it is, and that's in the record.
Your time has expired. Thank you for your...
Good morning, Justices. May it please the Court. Lisa Hurley, representing the Florida Bar. The Florida Bar supports the referee's recommendation of disbarment.
And I do want to go back to that. Can we do what, if anything, does the role of this respondent thinking that he is being persecuted by the Florida Bar, and has said this during apparently even the final hearing about that it's a conspiracy, apparently according to the referee's report mentioned Jews and homosexuals are out to get him for his well-known religious and moral views, and that those statements were not helpful to the court, at least that court, in determining whether the bar could meet its burden of proof. So let's take that all out of the equation. That is that this man, this respondent, whether people agree or disagree with his views, have a right outside of a court hearing or outside of his role as an attorney to espouse views that others consider to be inappropriate. What, for this violation, which is client neglect, why disbarment? I mean, it seems extreme.
And I understand. Disbarment's appropriate when you take into account the aggravating factors that the referee found in this case.
But the bar thought it was only 91 days. That's what the bar thought was appropriate here. Am I correct?
Yes, you're correct.
What changed this all of a sudden? Because somebody didn't like him during the hearing, or he didn't smile enough? I mean, what changed?
Unfortunately, this court doesn't have the ability to view the record. The respondent was directed to file the transcripts pursuant to the court's February 15, 2012 order. However, he failed to do so. So what we have before the court is the report of referee. It was his conduct during...
you say we've got no record. So we can't, there's no basis for us to decide that there's not competent substantial evidence for what's in the referee's report, right? Maybe I'm missing something here.
No, the referee filed a very detailed report of referee. I believe it was 35 pages long.
What Justice Kagan is asking is there's nothing upon which the court would have to base a rejection. I think that's what he's asking. Is that
what I said?
What he just said?
Yes, to find, I'm sorry, maybe I misunderstood. To find that there is not substantial competent evidence to support the findings, yes.
If there's no record of the proceeding before the referee, and the respondent has failed to provide that to us, then we've got to accept all of the factual conclusions of the referee. I mean, there's absolutely there's no room to do anything else. Isn't that correct?
I would agree.
And that's where we are.
Yes.
Well, it looks like, just since that the major reason that the referee elevated this above what the bar was asking for, because we have an independent duty anyway to look at, certainly on guilt, I think that's true. On sanction, we've got to look. I mean, her report apparently relies heavily on the prior disciplinary history. So let's go over that. The last discipline. They had 2 admonishments in 1993. Those were 20 years after he started practicing law. What were those? Does the record reveal what those admonishments were for?
Yes. The report of referee outlined what each discipline was for.
Okay, just to give it quick, sure. Could you tell me?
One admonishment was for him for respondent failing to advise the client in an alimony action of a settlement offer after the expiration of the offer, and for failing to return numerous phone calls to the client.
So a client neglect kind of situation.
Yes.
Okay, then public reprimand in 2000.
Well, there were 2 admonishments. The second admonishment was for client neglect as well.
Are all of these client neglect cases?
No.
What was the 30 days in 2007?
The 30 days in 2007, the bar entered into a consent judgment with respondent for his failure. There were 4 counts. His failure to respond timely to two of the counts, as well as failure to respond to a trust accounting subpoena in that case.
And it was, the court said it was, what was important to him is that this conduct, occurred shortly before the respondent had entered into a conditional guilty plea regarding other misconduct. And the other misconduct had to do with trust account? What was the 2007?
The underlying cases, the allegations surrounded improper billing of the clients after the clients had terminated the services of the respondent.
Did the bar sought 91 days in this case?
Yes.
Did it argue for more than that in the at any time? I just guess I'm concerned about a disparity. I mean, it seems to me that a suspension over 90 days is warranted based on the history of the history. But just give me again where this then rises to disbarment.
Yes, if I may clarify, in that disciplinary history, there were 2 public reprimands, and those public reprimands were for a case in which the respondent sent a letter to a client or to the victim of his client who was being prosecuted criminally for false imprisonment and battery, and that letter to the victim was found to have been intended to embarrass, humiliate, and intimidate the alleged victim in that case. Similarly, around the same time, he also received a public reprimand in a second individual case for speaking out, writing and publishing disparaging comments about an opposing counsel in a matter, and as well as a guardian ad litem in that same case. The bar prepared their recommendation for a 91-day suspension prior to the trial proceeding. So we didn't have the opportunity. We went right in from the 2 days of trial into the sanction hearing immediately the 3rd day. So we didn't have the opportunity to take into full consideration Mr. Buckles' conduct, which he demonstrated during the trial proceedings itself.
Well, now there's the problem, because the conduct, we have the referee's report. It seemed to me that she was mainly relying on the previous history that had occurred. This misconduct that's the subject of disbarment occurred in 2007? Is that correct? All right. The referee's report was rendered in July of 2011? Correct. I mean, that's the date it was?
Yes.
Okay. Is this respondent under emergency? Is he been suspended?
No, he's under no
emergency.
So
the court, the bar, and the bar has the ability, once there's a disbarment, to seek an emergency suspension. The bar has not been concerned about, even though he's had this pattern of protecting the public from the respondent for really a 5-year period. Are there any other pending charges against him right now?
Currently, there's been a finding of probable cause with respect to the judicial referral of the first referee in this case with regard to the motion to appoint new referee. However,
you mean to conduct that occurred in 2007?
During this disciplinary proceeding.
So this seems to be, that part is arising out of, what did he say in that she was, he referenced sexual orientation?
Yes.
Okay. So not a client harm. Is there any indication the bar at any time asked for a mental health examination or anything as far as the mental state of the respondent?
Not that I'm aware of.
Okay. So going back to just all of our cases, I'm just not seeing where disbarment ends up being. I'm just, I'm looking, I'm sympathetic to what's going on here, and a lot of things that this respondent says is definitely offensive, but offensive. There are a lot of people that offend both ways, that we have out there. And we've got to just be sure that we're making the right decision for the right reasons. So give me your best argument about why this is a disbarment case. That means that he is banned from the practice of law, and cannot re-enter until he takes the bar exam for something that occurred in 2007, where he hasn't been suspended for the 5 years between when this occurred and the present time.
Would ask the court to focus on the aggravating factors which the referee detailed in her report of referee.
Now, for those aggravating factors, do we need a transcript to know whether those are? I mean, those are just prior bar disciplines.
Well, there were multiple aggravating factors. There was consideration of his prior disciplinary offenses. There was dishonest or selfish motive.
Well, that we can, but that's from the facts of this case. That he wanted more money before he filed anything. Is that right? Or something about? What does that come out of? The dishonest motive.
The referee found that he ostensibly fired the client in March 2007 when he wrote a letter saying he was not going to do any more work on this client's case. Then he serves the 30-day suspension some months later without notification to this client of that suspension.
Okay, so it has to do with the facts of this case, of how he handled this case.
Yes.
Okay. What other aggravating circumstances?
The referee really focused on the fact that there's a pattern of misconduct and focusing on, he had 2 prior admonishments back in the 90s for client neglect.
All right, but is there something that we can't do in looking at the same pattern? Let's just say it was reversed. Say it was a 91-day suspension, and the bar was arguing it should be disbarment based on the escalating pattern or the pattern. There's something else that we're missing because we don't have the transcript that we need to rely on the referee for.
It's difficult without the transcripts to relay the referee's consideration of his conduct during the course of the trial proceedings itself, in making a lot of her findings with respect to the aggravation. Pattern of conduct is important in that you have a continuing course of conduct with respect to neglect, which he was disciplined for back in the 90s, and 13 years later, as the referee pointed out in her report, you see no improvement on. And then his conduct that, in the way he handled himself during the course of the proceedings, by attacking everyone involved in the case, the bar's fee expert, the client.
Well, we can see that because it was done right here in the court. I understand that this is this situation is very disturbing. You can't go ahead and just because somebody is prosecuting you or we're asking questions, assume that the motive is something other than trying to do the best for making sure the bar maintains high standards of lawyer conduct. And that is not, I appreciate that. And it must have been, but I'm still not sure whether that itself, if he's not, is he doing this in court proceedings? Is he representing clients and saying things in front of judges when he's representing his clients in court? Is he accusing judges of being, blacks or Jews or lesbians in front of, for his client, or not accepting clients, or, that's the kind of thing then affects it. But and that would, either that's a genuinely held belief, or it's maybe indicative of some mental issues, but the bar didn't explore that. So tell me what else.
Well, he's been disciplined for that type of conduct in the past.
The type where he's said bad things,
conduct
disparaging.
Prejudicial to the administration of justice,
And what was
humiliating, disparaging.
What did he say, and what's in the record? Because we have, obviously, all the discipline is in our record, even if it's not in the transcript. We've got that in the court files. So what has he done in the past?
in the case where this court rendered a written opinion to him was the letter that he wrote to the victim in a criminal case, which was, the court found, intended to embarrass, humiliate, and intimidate the victim into potentially withdrawing her, not going forward with the matter. And then he also has demonstrated that he's speaking out and writing and publishing to the court disparaging comments about opposing counsel and the guardian ad litem. So he's demonstrated this course of conduct in the past for which he's been disciplined. The court very eloquently, in the opinion that they wrote to Mr. Buckle prior, pointed out that zealous advocacy cannot be translated to mean win at all costs. And although the line may be difficult to establish, standards of good taste and professionalism must be maintained while we support and defend the role of counsel and proper advocacy. During the course of this disciplinary proceeding, he's demonstrated that advice, he doesn't seem to understand that advice.
Well, you seem to be suggesting then that there's an enhancement because of just the way he defended himself in this case, not on some separate charge that's been filed with the bar grievance.
Well, the court can consider uncharged conduct with respect to aggravation.
I'm just asking the question. That's what this is about then? There's not a pattern of ignoring clients. It's that people is the views that have been expressed that have produced where we are today. Well,
no, there's a pattern of the court of neglecting clients in that he was neglecting clients in '93, and we're before this court because of client neglect as well.
Why didn't the bar recommend suspension? Disbarment initially, since you knew all of this going in? Did you not?
We didn't have the vantage point of considering his conduct during the course of the trial proceeding.
You didn't have the charges, the previous charges against him?
We had his prior disciplinary proceeding, but it's the course of conduct that he demonstrated during the disciplinary proceedings itself that led the referee to the conclusion that
he's not
rehabilitation is improbable.
And yet, for 5 years, he's been allowed to practice law. That's it's not automatic that every case that involves, but the bar, after the report, did not seek to have this respondent suspended. They weren't concerned that he should continue to represent clients. Anyway, that's my, when we talk about the ultimate penalty, I think we just have to be careful that we don't mix our own personal, feelings with it, and on both sides.
Well, in addition to the pattern of conduct, the referee keenly focused on his demeanor and his refusal to acknowledge the wrongful nature of his conduct.
Well, that is, not fine. If he didn't think he did anything wrong, and he just still doesn't, I agree with that. But that still doesn't mean, when somebody doesn't agree, that it's a disbarment case.
You've exceeded your time. Thank you for your arguments. Court is adjourned.
All rise.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.